Welcome back to another incredible story of justice and unexpected turns. Before we begin, comment where you're watching from today. Now, let's dive into a tale that proves appearances can be deceiving, especially in the world of law and justice. In the heart of New York City, on a crisp autumn morning, a story unfolded that would leave the legal community stunned and social media buzzing for weeks. It began with what seemed like a simple dress code violation but evolved into a masterclass in constitutional law, featuring none other than Hollywood star Hugh Jackman. The incident took place at the Manhattan Federal Courthouse, where Judge Eleanor Martinez was known for her strict adherence to courtroom protocol and unwavering enforcement of dress codes. On this particular morning, she had no idea she was about to face off against someone who had spent months preparing for this very moment. Hugh Jackman walked into courtroom 318 wearing what appeared to be an ordinary silver cross necklace. The small piece of jewelry caught the fluorescent lights, drawing immediate attention from the court officers. In any other courthouse, on any other day, this wouldn't have warranted a second glance. But Judge Martinez had recently implemented a controversial new policy banning all religious symbols from her courtroom, claiming they could influence jury decisions. As Jackman took his seat in the gallery, the tension in the room began to build. The regular courthouse staff exchanged knowing glances. They had seen Judge Martinez's zero-tolerance policy in action before. Some had even started taking bets on how quickly she would notice and react to the apparent violation. The actor's presence in the courthouse that day wasn't for any Hollywood-related matter. He had come to support a friend in a minor civil case, choosing to sit quietly in the back row. But his subtle act of defiance was about to transform this routine court session into a watershed moment for religious freedom in American courtrooms. Judge Martinez's sharp eyes didn't take long to spot the gleaming cross. Her reaction was swift and characteristic of her reputation. She interrupted the ongoing proceedings, her voice cutting through the hushed whispers of the courtroom like a knife through butter. "Sir, in the back row with the cross necklace, approach the bench immediately." The gallery fell silent. Everyone expected to witness another quick submission to the judge's authority, another routine fine, another quiet removal of religious symbols. But they didn't know what Jackman had been doing for the past 6 months, working closely with constitutional lawyers and religious freedom experts, meticulously preparing for this exact scenario. As Hugh Jackman rose from his seat, there was something in his demeanor that caught the attention of every legal professional in the room. It wasn't the confident stride of an actor used to commanding attention, but rather the measured approach of someone who knew exactly what was about to unfold. In his hand, he clutched a small leather portfolio that nobody had paid attention to until now. The famous actor's face showed no sign of intimidation as he approached the bench. Instead, there was a subtle smile playing at the corners of his mouth, the kind of smile that suggested he knew something the judge didn't. The kind of smile that made several veteran lawyers in the room sit up straighter in their seats, sensing that they were about to witness something extraordinary. What happened next would not only challenge Judge Martinez's authority but would also set in motion a series of events that would reshape courthouse policies across the country. As Jackman stood before the bench, about to speak his first words, not a single person in that courtroom could have predicted the legal battle that was about to unfold. A battle that would demonstrate how one man's quiet act of defiance, backed by brilliant legal strategy, could change the landscape of religious freedom in American courts forever. The air in the courtroom grew thick with anticipation as Judge Martinez prepared to levy her standard fine, unaware that she was about to encounter one of the most sophisticated legal challenges to her authority that her courtroom had ever seen. Hugh Jackman's presence was about to transform from that of a simple observer to a pivotal figure in a constitutional showdown that would be studied in law schools for years to come. Judge Martinez's voice carried through the now silent courtroom as she addressed Hugh Jackman directly. "Mr. Jackman, are you aware of this court's policy regarding religious symbols?" Her tone was measured but stern, the kind that had made countless others quickly comply with her rules. The judge's hand was already moving toward her gavel, ready to impose the standard $500 fine she had levied on dozens before him. But Hugh Jackman's response would mark the beginning of a legal chess match that nobody had anticipated. "Your Honor," he began, his voice carrying the same quiet authority that had commanded movie screens worldwide, I am not only aware of the policy but also of its constitutional implications under the First and 14th Amendments, as well as the Religious Freedom Restoration Act of 1993. The subtle shift in the judge's expression was noticeable to everyone in the courtroom. This wasn't going to be the usual quick submission to her authority. Jackman opened his leather portfolio, revealing a meticulously organized collection of legal documents, each tab color-coded and labeled with precision that would impress even the most detail-oriented law clerk. Your Honor, before you proceed with any fine, I would like to present several precedent-setting cases that directly address the constitutionality of religious symbol bans in government buildings. Jackman's words weren't delivered with the dramatic flair of his theatrical performances, but rather with the measured precision of a seasoned legal professional. He pulled out a document from the first tab of his portfolio, beginning with the Supreme Court's decision in Good News Club versus Milford Central School, which established that religious discrimination in government spaces constitutes viewpoint discrimination. The gallery watched in amazement as Judge Martinez's usual quick dismissal of challenges to her authority gave way to a more cautious approach. She leaned forward, her reading glasses perched on the edge of her nose, examining the case law Jackman had presented. Mr. Jackman, while I appreciate your preparation, this court's policy exists to maintain neutrality and prevent any undue influence on jury members. Jackman nodded respectfully before reaching for another document. I understand your concern for neutrality, Your Honor. However, I direct your attention to Capitol Square Review Board versus Panett, where the Supreme Court held that religious expression cannot be banned solely because of its religious character. Furthermore, he produced another document with the smoothness of a magician pulling cards from a deck. The Second Circuit's recent decision in Zhang versus Metropolitan Authority specifically addressed religious jewelry in government buildings. The atmosphere in the courtroom had transformed completely. Law students who had come to observe routine proceedings were now furiously taking notes. Several attorneys present for other cases had abandoned their phones and paperwork, entirely engrossed in the constitutional law masterclass unfolding before them. Judge Martinez's reputation for quick decisions and unwavering enforcement of her policies was being tested in a way no one had ever witnessed. Mr. Jackman, she interjected, are you represented by counsel today? There was a note of curiosity in her voice, perhaps even a hint of respect beginning to form. No, Your Honor. However, I have spent the past 6 months studying constitutional law under the guidance of Professor Elena Montgomery from Yale Law School, specifically focusing on religious freedom cases in federal courts. Jackman's revelation sent whispers through the courtroom. Professor Montgomery was a legendary figure in constitutional law, known for her brilliant arguments before the Supreme Court. The judge's next words were careful, measured. And what prompted this extensive preparation, Mr. Jackman? This was the moment Jackman had been waiting for. He reached into his portfolio one more time, extracting a thick document bound in blue covers. Your Honor, this is a comprehensive analysis of every fine you've levied for religious symbol violations in the past 18 months. The pattern shows a concerning trend of religious discrimination that appears to disproportionately affect certain faith groups. The gallery erupted in hushed murmurs. Judge Martinez's face remained impassive, but her knuckles whitened slightly as she gripped her gavel. She had never faced such a well-prepared challenge to her authority, let alone from a Hollywood actor who had apparently transformed himself into a constitutional law expert. Furthermore, Jackman continued, his voice remaining respectful but firm, I have here sworn statements from 17 individuals who were fined in your courtroom for wearing religious symbols. Their testimonies reveal a pattern that, when examined under the strict scrutiny standard required by Employment Division versus Smith, raises serious constitutional concerns. A young law clerk rushed to the judge's side, whispered something in her ear, and handed her a note. Judge Martinez read it quickly, her expression growing more serious. The note likely confirmed what Jackman had just stated, that his legal argument was sound and backed by extensive research. Your Honor, Jackman pressed on, the Supreme Court has consistently held that any government policy that burdens the free exercise of religion must be both neutral and generally applicable. The selective enforcement documented in these cases suggests that your policy fails both tests. The judge removed her reading glasses slowly, a gesture that the regular courtroom attendees knew signified deep consideration. Mr. Jackman, are you suggesting that this court's policy violates the Constitution? Not suggesting, Your Honor. I am prepared to prove it. Jackman pulled out yet another document. I have here a motion for declaratory judgment, already filed with the Second Circuit, challenging the constitutionality of this policy. The motion includes an extensive analysis of similar policies that have been struck down in other jurisdictions, along with expert testimonies from 3 constitutional law professors and a former federal judge. The gallery watched in amazement as Judge Martinez, known for her quick and often harsh judgments, took several moments to process what was happening. Her courtroom had become the stage for a constitutional challenge that could potentially affect courtroom policies nationwide, and her anticipated routine fine had transformed into a pivotal moment in religious freedom jurisprudence. Additionally, Jackman continued, his voice never wavering, I've prepared a detailed statistical analysis showing how your policy has been enforced disparately across different religious groups. This analysis was conducted by Dr. Sarah Chun from Harvard's Department of Statistical Analysis, and it reveals some troubling patterns that I believe this court would want to address before they become part of the public record. The tension in the courtroom was palpable. Everyone present knew they were witnessing something extraordinary, a carefully orchestrated legal challenge that had been months in the making, disguised as a simple dress code violation. Hugh Jackman, the actor known for playing Wolverine, had transformed himself into a formidable legal advocate, armed with an arsenal of constitutional law arguments and precedent-setting cases. Judge Martinez finally spoke, her voice carrying a note of respect that few had ever heard in her courtroom. Mr. Jackman, I believe this matter warrants further discussion. Please approach the bench with your documents. She turned to her clerk. Clear the afternoon calendar. This requires immediate attention. As Jackman gathered his materials and approached the bench, the gallery buzzed with excitement. Law students were already texting their professors about what they had witnessed, and several court reporters were rushing to file their stories. This wasn't just about a cross necklace anymore. It was about to become a landmark case in religious freedom jurisprudence, all because one man had decided to challenge an unjust policy with meticulous preparation and unwavering determination. The afternoon that followed would go down in legal history as the day a Hollywood actor turned constitutional scholar took on an established federal judge, and changed the landscape of religious freedom in American courtrooms forever. But as Hugh Jackman laid out his documents before Judge Martinez, this was just the beginning of a legal battle that would captivate the nation and redefine the boundaries between judicial authority and religious liberty. The afternoon session of Judge Martinez's courtroom had transformed into an impromptu constitutional law seminar. The gallery, now packed with lawyers, law students, and journalists who had heard about the morning's events, watched intently as Hugh Jackman methodically laid out his case. The actor's usual charismatic presence had been replaced by something entirely different, the precision of a legal scholar about to dismantle an unconstitutional policy piece by piece. Your Honor, Jackman began, holding up a comprehensive chart. This analysis shows that over the past 18 months, your courtroom has issued 73 fines for religious symbol violations. 68 of these fines were levied against members of minority religious groups, while only 5 were issued to individuals wearing Christian symbols. This disparity alone raises serious equal protection concerns under the 14th Amendment. Judge Martinez studied the data, her usual stern demeanor showing cracks of concern. Mr. Jackman, correlation does not imply causation. These numbers could be explained by the demographic makeup of court attendees. A slight smile crossed Jackman's face as he produced another document. I anticipated that argument, Your Honor. Here is a demographic analysis of all court attendees over the same period, compiled from public records. The religious distribution of courtroom attendees shows no significant correlation with the pattern of fines imposed. In fact, the statistical probability of this enforcement pattern occurring by chance is less than 0.001%, according to Dr. Chen's analysis. The judge's clerk frantically typed notes as Jackman continued his presentation. Furthermore, Your Honor, I direct your attention to the case of Singh versus Carter, where the D.C. Circuit Court held that even seemingly neutral policies must be struck down if their enforcement demonstrates a pattern of religious discrimination. But Jackman wasn't finished. He reached into his portfolio and extracted a sealed envelope. This morning, I received this letter from the Department of Justice's Civil Rights Division. They have expressed significant interest in the enforcement pattern of your policy and have initiated a preliminary investigation into potential violations of the Religious Land Use and Institutionalized Persons Act. A collective gasp rippled through the courtroom. Judge Martinez's face paled slightly as she accepted the letter. The involvement of the DOJ's Civil Rights Division elevated this from a local courtroom dispute to a federal civil rights issue. Additionally, Jackman continued, his voice remaining measured and respectful, I have statements from 3 members of the Senate Judiciary Committee expressing concern about the constitutional implications of courtroom religious symbol bans. They are particularly interested in how such policies might conflict with the Religious Freedom Restoration Act's requirement that government actions imposing substantial burdens on religious exercise must be the least restrictive means of achieving a compelling government interest. Judge Martinez removed her glasses, pinching the bridge of her nose. Mr. Jackman, while your preparation is impressive, what exactly are you seeking here? Surely this elaborate presentation isn't just about avoiding a $500 fine. This was the moment Jackman had been waiting for. He pulled out a final document, bound in dark blue leather. Your Honor, this is a proposed consent decree that would not only address the constitutional issues with your current policy but could serve as a model for courtrooms nationwide. It was drafted in consultation with religious liberty experts from the American Civil Liberties Union, the Beckett Fund for Religious Liberty, and the Stanford Religious Liberty Clinic. The judge's eyebrows raised at the mention of these prestigious organizations. Jackman continued, the decree would establish clear, constitutionally sound guidelines for religious expression in courtrooms while maintaining the judicial dignity and neutrality you rightfully seek to protect. It includes provisions for: first, a clear and objective standard for determining when religious symbols might genuinely interfere with courtroom proceedings, based on size, visibility, and potential for disruption rather than religious content. Second, a transparent appeals process for any restrictions on religious expression, overseen by a diverse panel of legal experts and religious liberty scholars. Third, mandatory training for court staff on religious accommodation and constitutional protections for religious expression. Fourth, quarterly audits of enforcement patterns to ensure no religious group faces disproportionate scrutiny. As Jackman spoke, several prominent civil rights attorneys in the gallery nodded approvingly. The proposed solution was elegant. It addressed the court's legitimate interests while protecting constitutional rights. Judge Martinez studied the consent decree carefully. Mr. Jackman, this is remarkably thorough. But I must ask, why did you choose this particular approach? Why not simply file a lawsuit or seek media attention? Jackman's response revealed the full scope of his strategy. Your Honor, my goal was never to embarrass the court or create a media spectacle. It was to address a systemic issue in a way that could benefit everyone. This approach allows the court to be part of the solution rather than the target of criticism. It transforms what could have been a confrontational lawsuit into a collaborative effort to protect both judicial integrity and religious freedom. He paused, then added, moreover, I chose your courtroom specifically because of your reputation for fairness and attention to detail. I believed that once presented with comprehensive evidence and a viable solution, you would recognize the opportunity to set a positive precedent for courts nationwide. The strategic brilliance of Jackman's approach was becoming clear to everyone in the courtroom. By choosing to confront the issue directly, armed with irrefutable evidence and a practical solution, he had transformed what could have been an adversarial legal battle into a chance for positive systemic change. Judge Martinez rose from her bench, an unprecedented action that signaled the gravity of the moment. Mr. Jackman, in 20 years on the bench, I have never encountered such a thoroughly prepared and thoughtfully presented challenge to court policy. I believe we need to take a brief recess while I review these materials in detail with my staff. As the judge left the courtroom, the gallery erupted in excited whispers. Law professors present began impromptu discussions with their students about the brilliant legal strategy they had just witnessed. Court reporters rushed to file updates on what was quickly becoming a landmark moment in religious freedom jurisprudence. Jackman remained at the counsel table, calmly organizing his documents. His demeanor suggested he knew that the hardest part was yet to come, transforming this moment into lasting change that would protect religious freedom in courtrooms across the country. After 45 minutes that felt like hours, Judge Martinez returned to the bench. The courtroom fell silent as she prepared to speak. Her face showed signs of deep contemplation, and perhaps a hint of admiration for the thoroughness of Jackman's presentation. "Mr. Jackman," she began, her voice carrying a new note of respect, "your presentation today has forced this court to confront some uncomfortable truths about the unintended consequences of our policies. While maintaining order and neutrality in the courtroom remains paramount, it cannot come at the expense of constitutional rights." She lifted the consent decree. This document presents a thoughtful and practical approach to balancing these competing interests. I am prepared to accept its general framework, though I would like to work with you and the other involved organizations to refine some specific provisions. The gallery broke into murmurs of excitement, but Judge Martinez wasn't finished. "Furthermore, I am ordering an immediate stay on all religious symbol fines pending the implementation of the new guidelines. And Mr. Jackman," she paused, a slight smile crossing her face, "I believe you've demonstrated that legal genius can come from unexpected places." The impact of this moment would resonate far beyond the walls of that Manhattan courtroom. Hugh Jackman had just demonstrated how careful preparation, respect for legal institutions, and a commitment to positive change could transform a simple act of civil disobedience into a watershed moment for religious freedom in America. News of what transpired in Judge Martinez's courtroom spread through legal circles like wildfire. Within hours, the story of how Hugh Jackman had transformed from Hollywood star to constitutional law champion dominated both legal blogs and mainstream media. But the real impact of his carefully orchestrated challenge was just beginning to unfold. 1 week after the historic confrontation, Judge Martinez's courtroom was packed for the formal signing of the amended consent decree. Representatives from major civil rights organizations, religious leaders, and legal scholars had gathered to witness what many were already calling a watershed moment in religious freedom jurisprudence. The signing of this decree, announced Judge Martinez, her voice carrying newfound warmth, marks not just a change in this court's policy, but a commitment to ensuring that justice and religious liberty can coexist harmoniously in our legal system. She turned to Jackman, who sat quietly in the front row. Mr. Jackman's approach to challenging this policy has set a new standard for constructive legal advocacy. The impact of Jackman's victory rippled through the judicial system with remarkable speed. Within a month, 23 federal judges had voluntarily adopted similar guidelines for religious expression in their courtrooms. The Administrative Office of the U.S. Courts formed a special committee to study the implementation of comparable policies nationwide. But the most surprising developments came from unexpected quarters. Law schools across the country began incorporating the Jackman case into their constitutional law curricula. Professor Elena Montgomery, who had guided Jackman's legal studies, developed a new course titled Creative Advocacy: Innovative Approaches to Constitutional Challenges. What Mr. Jackman accomplished, Professor Montgomery explained to a packed lecture hall at Yale Law School, was more than just a victory for religious freedom. He demonstrated how thorough preparation, respect for legal institutions, and innovative thinking can transform a simple act of civil disobedience into a catalyst for systemic change. The media's fascination with Jackman's legal expertise led to unexpected opportunities for broader education about religious freedom. Late-night talk show appearances transformed into impromptu constitutional law lessons. His interview on 60 Minutes became required viewing in civil rights law classes. "People ask me why I chose this particular battle," Jackman explained during the interview, his expression thoughtful. "The truth is, I saw an opportunity to address a larger issue in a way that could bring about positive change rather than division. Sometimes the most effective challenges to unjust policies come not from confrontation, but from collaboration." 3 months after the courtroom showdown, the Department of Justice's Civil Rights Division released a comprehensive report on religious symbol policies in federal courts. The report cited the Jackman-Martinez guidelines, as they had come to be known, as a model for balancing judicial decorum with religious liberty. The impact extended beyond American shores. Courts in Canada, the United Kingdom, and Australia began reviewing their own policies on religious expression. International legal journals published detailed analyses of how Jackman's approach could be adapted to different legal systems and cultural contexts. Perhaps the most touching responses came from ordinary citizens who had previously faced similar discrimination. Letters poured into Jackman's production company, sharing stories of religious expression challenges in various settings: schools, workplaces, government buildings. One particularly moving letter came from a Sikh law student who had been hesitant to wear his turban while arguing cases in moot court. Mr. Jackman's victory reminded me that my religious identity and my legal career aren't mutually exclusive, he wrote. His actions showed that standing up for religious freedom can be done with dignity and respect for legal institutions. The entertainment industry took notice as well. Offers flooded in for Jackman to play legal roles, but he declined them all. This wasn't about acting, he explained during a press conference. It was about using whatever platform you have to affect positive change. Sometimes that means stepping out of your comfort zone and taking on challenges nobody expects you to face. 6 months after the initial confrontation, Judge Martinez and Jackman appeared together at a judicial conference to discuss the implementation of the new guidelines. Their presentation focused not just on the legal principles involved, but on the importance of approaching constitutional challenges with respect and openness to dialogue. What impressed me most about Mr. Jackman's approach, Judge Martinez admitted to the assembled judges, was his recognition that lasting change requires more than just winning a legal argument. It requires creating a framework that everyone can embrace and implement effectively. The conference became an annual event, bringing together legal professionals, religious leaders, and civil rights advocates to discuss ongoing challenges and improvements to religious freedom protections in the legal system. The Jackman Fellowship was established, funding law students who proposed innovative approaches to protecting constitutional rights. 1 year after the historic confrontation, a follow-up study revealed that religious symbol-related incidents in federal courts had decreased by 94%. More importantly, the few incidents that did occur were handled through a transparent appeals process rather than immediate punitive measures. The transformation of court culture was evident in small but significant ways. Court officers received regular training on religious accommodation. Informational brochures about religious expression rights were available in every federal courthouse. A diverse advisory panel reviewed religious expression policies quarterly to ensure fair implementation. Hugh Jackman's personal transformation continued as well. He enrolled in law school part-time, focusing on constitutional law and civil rights. His fellow students reported that he approached his studies with the same meticulous attention to detail that had characterized his courtroom challenge. The law is like acting in one important way, Jackman explained to his classmates during a study group. Both require you to understand human nature and tell compelling stories. The difference is that in law, those stories can change lives and protect fundamental rights. 2 years after the case, during a special session of the American Bar Association, Jackman was awarded an honorary membership in recognition of his contributions to constitutional law. His acceptance speech focused not on his achievement but on the ongoing work of protecting religious freedom. What happened in Judge Martinez's courtroom wasn't just about one policy or one cross necklace, he said. It was about recognizing that our legal system is strong enough to accommodate both religious expression and judicial dignity. It was about proving that change can come through collaboration rather than confrontation. The story of Hugh Jackman's legal genius continues to inspire new generations of advocates. Law school applications began citing his example in their personal statements. Civil rights organizations developed training programs based on his methodical approach to challenging discriminatory policies. As this story comes to a close, we're reminded that true legal genius isn't just about knowing the law. It's about understanding how to use that knowledge to create positive change. Hugh Jackman's transformation from actor to legal advocate shows that expertise can come from unexpected places, and that justice is best served when we approach challenges with thorough preparation, respect for institutions, and a commitment to constructive solutions. If you've enjoyed this incredible story of how one man's careful preparation and innovative thinking changed the landscape of religious freedom in American courts, make sure to like and subscribe. Share this video with someone who needs to be reminded that standing up for your rights can be done with dignity and grace. Comment below with your thoughts on this remarkable case, and don't forget to ring that notification bell to stay updated on more amazing stories of justice and transformation. Remember, in the words of Hugh Jackman himself, the most powerful advocacy comes not from confrontation, but from showing others a better way forward. Until next time, keep seeking justice and standing up for what's right.